see, if the court intervenes, the court must at least know there's going to be some benefit for the court to stop the project. Because it appears as if the developer is saying, look, we'll continue with this building at our own risk. Let the review go ahead. If we need to break down the wall, reduce the levels, if you're on the 5th floor and we must break down the walls, we'll do that if it's required of us. So I need to know what is the benefit for the applicants if the court stops the construction. Yes, the review is going to be heard, but I need to know beyond that. What is it that the applicant wants, and is it feasible? Is it doable? Is it sustainable? Is it economically viable? Should the court stop this, building the construction at this stage?
Well, lady, it seems to me that there is something in the nature of a case for that to happen, because at the moment it is being investigated by Heritage Western Cape, formally proclaiming the area. And that is a statutory option, and I'll come to where the reports fall short as far as that is concerned.
But the problem is the provisional protection is no longer valid. So the court is not even sitting with a piece of land that is being provisionally protected, because that could even have made it could have made the court's life a bit easier, the decision easier. You have a piece of land, it's protected, it looks as if it's on its way to attain some form of status, and it looks as if the conditions that were posed could possibly be tweaked a bit. So,
well, if you're putting it the level on its way, it seems that, and I think that is on the record, that is a distinct possibility because it's under consideration at the moment. So, and we would submit that's, particularly if one looks at what the alternatives were that had to be considered.
So I would imagine
that's good enough, we would say.
So I would imagine if this court is not with the applicant, and this court decides construction can proceed, it's at their own risk, they must just suffer the consequences after the developer and whoever must suffer the consequences after the review is heard. By the same token, this court, I just lost now my thought process now. Oh, yes, this is what I wanted to say. But by the same token, the court can say construction can proceed, and if the court grants that order, that the construction may proceed, what the applicant is saying now is, once the court hands down that order, there is a possibility that the site may be declared as a protected site after the court hearing. So, should that happen, in that eventuality, would the applicants then not be in a position to come back to court and say, look, now we have a place, we have property, it's the site has provisional protected status, and we want the court to reconsider its position. I'm just throwing it out there to ask the applicant, because there is nothing definitive. There's no concrete. Nothing concrete for the court to hold on the idea that the property will be declared a heritage site as we sit here today. There's nothing.
Well, I don't think one can say nothing, lady. In fact, I put it to you incorrectly. The position's a little bit stronger.
Yes.
Because the body that's considering it, I was wrong saying it was Heritage Western Cape. It's the South African Heritage Resources Authority that is presently investigating the declaration as a national heritage site.
Yes.
And with respect, lady, that puts it at, I would respectfully submit, quite a high level. Because what you will then have is a developer who's not only acting illegally with reference to the rule of law, but on top of that is preventing another lawful statutory process from going ahead at national level. And we know from the record that the area, from the point of view of the freedom struggle, has a real significance. The battle, that's a little bit controversial and we can debate it, was referred to by the President in one of his speeches.
But that is a different application to come to court and say, we are seeking an interdict to stop construction on the basis that this site is currently being considered as a national heritage site. That is a different application. It's actually a much easier application than this one.
Certainly, that's obviously one of the things that could happen.
Yes.
At the same time, one have to take into account the perhaps hesitation of state bodies to get involved in litigation.
Yes.
But it doesn't eliminate it as a very relevant consideration for the current matter. Highly relevant consideration for the present matter. And there's a statutory, and as I'll come to, there's a statutory basis for that, which I think hasn't been correctly understood in the proceedings to date because of a misinterpretation of the alternatives provision. So perhaps if I could just work through those and indicate to your ladyship. So if we complete our own mapping exercise, lady, that is not on the record.
I see.
Can I read it?
Yes. Wait, just hold on. Perhaps you shouldn't read anything that's not on record. I don't want to prejudice any parties. You see?
I think it is on record. They're going to look for it, lady. I won't read it until...
Well, the applicant did mention something about World Heritage Site or National Heritage. That's why I'm engaging the applicant as to the way forward should the court be against the applicant for that matter. And what I actually also try to establish, if this court goes against the applicant may just have another opportunity to approach the court to stop the project, should this court go against the applicant. The applicant may have another opportunity once the South African Heritage decision is made. The South African Heritage Council decision is made.
They can't afford to pay me, so... So
it will most certainly not then be the end. This is what the applicant is telling the court now. It won't be the end of the road if this court must go against the applicant.
Well, I think realistically it will be the end of the road. The construction is proceeding at pace.
Yeah.
And the notion that the respondents have conveyed that those buildings are going to get put up and then knocked down when the review application is won, it ain't going to happen with respect, my lady. It's just not conceivable, and the submission is completely inconsistent with the Camps Bay Residents and Ratepayers judgment versus Augustino, I think it is, that I referred your ladyship to. They talk about the problem of the developer building themselves into an absolutely impregnable decision where they start dictating outcomes and creating a situation of bias in their favor. And that's exactly the situation that we're faced with here.
Because the review court can ultimately decide, look, there were irregularities, but ultimately where we are now today, the court is not going to interfere.
Particularly given the broad discretion under Section 8 of PAJA.
So the applicant is saying the court, it's in the applicant's interest and in the interest of the protection of their cultural heritage to rather stop it.
Indeed, lady.
The court would like to assure the applicants that the court most certainly is mindful of the rights that are involved in this case. It's a very sensitive issue. The court is very much mindful.
As the court pleases.
Yes.
As the court pleases.
So the applicant's view is rather stop the development than cause further destruction of the natural state of the property at this stage. Yes.
Just to give you the reference in the record,
yes.
We understand it will tell us.
Volume?
It's page 751, volume 1, page 751. It says, however, the area was signed off by President Cyril Ramaphosa and the Cabinet in August 2020 as part of the Khoi and San National Liberation and Resistance Route. The Department of Arts and Culture has also tried to have it added to an updated tentative UNESCO list as a World Heritage Site. So, lady, to come back to the mapping under paragraph A, next place we need to go to is the supplement.
Can you just pause one moment? Is are the applicants saying that the mapping would have enhanced the significance of the property in question?
Not enhanced the significance, but better revealed and made accessible for a decision-making process the significance. So if your ladyship can then turn to Annexure LL15, your ladyship will see the area marked. Again, it's devoid of any actual mapping of heritage resources, tangible or intangible. And one can see there the site, but there's just nothing there. And they confirm that, in fact, it isn't what paragraph A envisages. They say, this diagram was not included in the HIA because several of the gradings of the site are wrong or outdated. For example, the so-called Black River, it looks like off-something site, is shown as a sports ground, and the SAAO site, 237, yes, my lady. So just the paragraph below the diagram.
Oh, I see.
So the long and the short of it is they say, here's a diagram, but it's not a diagram that works for paragraph A. Then, second, we copy here Atwell and Jacobs' composite diagram of heritage, potentially sensitive sites and heritage resources, which implies a rather different set of criteria, I think it is. And if we turn the page, this diagram was not included or referred to in the HIA because we think the diagram does not identify or capture the significances of the heritage resources for the area. Then, if we can go to the diagram below it, illustration 5, tangible and some intangible heritage resources. And again, if we look at the circle and the site, we see nothing specifically mapped as far as the site is concerned. And again, it's confirmed that as Postlethwaite's study dates from September 2019, it is self-evident that its findings could not be included in our HIA of 2 July 2019. And so on. But essentially, all they do is to confirm that it simply doesn't apply. If I can then jump around a little bit and look at paragraph F, there are two aspects we focus on in relation to paragraph F. And just to refresh our memories, paragraph F is the one that says if heritage resources will be adversely affected by the proposed development, the consideration of alternatives. And we respectfully ask your ladyship to look carefully at the wording of that provision, especially the first part of it. If heritage resources will be adversely affected by the proposed development, the consideration of alternatives. And we would submit that certainly if one considers the fact that expropriation is expressly provided for in the statute, and we say that on a proper reading of that provision, if they're going to be impacted, look for alternatives. In other words, we say the clear meaning must be alternatives that won't involve a negative impact on heritage resources or the least possible impact on heritage resources. And it says that you've got to look at what those might be. And we say, in addition, that one must interpret that provision purposively and in a manner that promotes the spirit, purport, and objects of the Bill of Rights, and a purposive methodology of interpretation. And on that basis, we submit that one certainly has to look at, as a statutory obligation, what the alternative protection measures are under the statute. And there's a range of them, a range of different declarations. There, as I've indicated, it's been suggested that it was a flight of fancy. We suggest that expropriation is a realistic alternative. It's private land. It means that the owners aren't prejudiced by a simple declaration. they get compensated for something that perhaps gets frozen, and the state can then do something there. And with respect, the law is clear that one can't interpret a statute on the basis that the state can't use its provisions. The court must interpret the statute on the understanding that the legislation can be operatively applied. Significant that when it comes to, in this context, that when it comes to the rivers, the respondents enthusiastically support the restoration of the Lesbiac Canal to something as close as possible to its natural state, despite being degraded and all of that stuff, great big concrete wall. They say it's fine, restore it, and it can become, you can declare it as a specially protected heritage area. We say, in principle, if you can do it for such a degraded canal, why can't you do it for the degraded land that goes next to the canal? Maybe the second component of the consideration of alternatives is this. The consideration of alternatives, whether in terms of section 38(3)(f), and it's important to bear in mind that it was suggested, I think, during argument from the first respondent, that the alternatives one is talking about here is the alternatives under the EIA regulations. We say no. This is a distinctive process. This Act is a 1999 statute. It predates the environmental impact assessment regulations. And we say that there's obviously, whichever one you happen to be applying, an obligation to act independently. And I've referred your ladyship to that. That would be statutorily required under this one. It's expressly required under the EIA. And each one must receive fair consideration. The pros and cons must all be conveyed in the assessment so that the provincial authorities can make a decision that is properly informed and considered from all perspectives, more especially where the development is contentious. Such an approach, we say, is excluded, and the statute is wrongly interpreted and applied when, and I won't go there again, but with reference to page 180, we saw in paragraph C the description of the professional role as being essentially to identify heritage resources and their significances and advise and assist owners to propose development that responds to the articulated significance. In the preface to the HIA, all alternatives other than the preferred development are excluded ab initio, and we're told that we think the choice is stark but clear, accept the currently proposed riverine corridor alternative with what we think are very considerable public benefits, or accept that the River Club property will remain as it is. And in the answering affidavit in these proceedings, we are told by the consultants themselves that they were engaged in finding the appropriate form of the development, quote unquote. That is not what paragraph F of the statute requires. So that, we say, is another failing that hasn't been successfully resisted by the respondents. And each of these failings on their own, because of the objectively justiciable nature of the first part of the proviso, would lead to a failure. There is then a discussion of paragraph E, and we've already had a discussion at the beginning of my argument, so I'll try and shorten what I had to say there. But there was a suggestion in argument on behalf of the fourth and fifth respondent that this particular provision imposes no self-standing consultation requirement, only a reporting requirement based on the wording. Report on the if we can just get the exact wording. So it says the results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. So that results is focused on, to say you don't have to consult, you just have to give the results of consultation. We submit that there are several difficulties with that interpretation. The provision cannot have been created with the reliance on the consultation provisions in PAJA in mind, because that is what I understood to be my learned friend's arguments, that you must source the consultation obligation in PAJA and then report on it under this particular provision. In the first instance, PAJA did not exist at the time of this particular statute, so that can't have been what Parliament intended. Nor can NEMA or the EIA public participation requirements be used as the basis for the consultation requirement, because Section 38(3) operates also when Section 38(8) does not apply, and the Heritage Authority is the one statutorily tasked with deciding on whether or not to allow the development. If we gave it that interpretation, compared with the EIA regulations, you'd end up without a basis for consultation. So, bearing in mind the latter scenario, it would mean that when the Heritage Authority is the decision maker on the authorization of the development, there is no statutory obligation at all. Yet there is still a reporting obligation. The section would then be complied with if the heritage practitioner simply reported there being no obligation under the statute, no consultation process was conducted. With respect, that cannot be correct. This approach to interpretation illustrates why another submission of my learned friends was wrong when they said that the amicus submissions are irrelevant and can be ignored. With respect, my lady, that is a surprising submission to make, considered against the peremptory terms of Section 39(1)(b) of the Constitution, must consider international law when interpreting a statute. Also out of line with the approach to interpretation required by Section 39(2)(b), promote the spirit, purport, and objects, on an interpretation that respects these two constitutional duties placed on a court, an obligation to report on the consultation process means that there must be an underlying lawful, meaningful, and constitutional consultation process that must in fact take place. And to determine the content of the consultation, there's ample authority from the courts. Additionally, where any component of the consultation sought to address the position of First Nation peoples applies, it must be one that takes into account the special obligations that arise in international law when the heritage rights of First Nations community are affected. These were summarized as those requirements that I've referred to, the 6 requirements that my learned friend took us through. Only focused consultation with some First Nation peoples, as we say, was that reflected in the First Nations report, but we have already discussed that. I don't think I need to take that any further. Lady, then, remaining component, the Minister's decision, we persist in saying that the Director in his letter of the 17th of Feb 2020, that's Annexure AB4, was talking about the failure to satisfy the requirement of the appointment of and report from a specialist consultant on intangible heritage. And my learned friend said, well, if you look at the letter, it doesn't refer specifically to that requirement of appointing a specialist consultant. But if you look at paragraph 37 of the answering affidavit, although they there cast it in the terms of a recommendation, they zero in very specifically on this particular part right at the end of the letter where they say, get a specialist consultant and get a report from them. So we know from the affidavit, not from the letter, that that's what he's talking about. And then in his letter he says, comply with the requirements. And I showed your ladyship where it uses the words, twice uses the word requirements. And that's the contemporaneous document, which must be the one that's more compelling. Even if it's a recommendation, even if we take it as that, it had to be in the minister's decision because it had a big asterisk next to it. It was a strong recommendation. I think they described it as. There's nothing to suggest that the minister treated it as such. In fact, effectively he rejected it because he didn't ask for it. He bashed on without it. So that can never, we would submit, amount to taking into account. In relation to irreparable harm, we have already made submissions when we were talking about OTA. We also referred in our initial argument to the affidavit of Mr. Jenkins when he describes the disembodiment that's involved, when he describes the pain that is inherent in intangible cultural heritage, being swamped by, as your ladyship put it, a concrete jungle. So with respect, we have great difficulty seeing how it can possibly be suggested that there isn't harm going on right now as the development proceeds. Indeed, we say if the respondent's conception of intangible heritage is that it is not affected by construction of these buildings on the site, that is compelling evidence of the failure of the heritage consultants to even understand the nature of intangible heritage, let alone assess significance and impact correctly. The First respondent persists in the issue of it having been degraded. I think we've already had a discussion about that. But the part I wanted to focus on in relation to my learned friend for the first respondent submissions is he said that the way you deal with intangible heritage is to document, record, and memorialize. With respect, my lady, that cannot be. That is to ossify it. The term used for intangible heritage in the statute is living heritage. I need say no more than that would not be living heritage. We can then come to the issue of the balance of convenience. We refer to the judgment of Lord J, which I've referred to a couple of times. Just in relation to that judgment, it's in the notes. I don't need to go there in, and I've indicated what it says. But the line that's important is this one. The stronger the prospects of success in the review proceedings, i.e. the prima facie right, the greater the subordination of prejudice occasioned by a cessation of the building work. Otherwise stated, the principle of legality tends to operate decisively in this context. And that's what we say needs to happen in this case. What the learned judge is articulating is that we are a society governed by the rule of law. We are not a society governed by the rule of concrete. Although brought under PUDGA, the essence of the challenge to the NEMA decision-making process is a legality-type challenge, so we tick that box as far as that aspect of the judgment is concerned. And on an application of the principles laid down in this judgment, we say that the construction most certainly stands to be stopped. To the extent that any balancing exercise is required to be conducted, it is submitted that in the context of this matter, it is, and I think your ladyship has pointed that out appropriately with respect, it is a matter to be approached with extreme caution. The value of the constitutionally protected heritage and cultural rights which the applicants seek to protect, rights which have their origin in the birth of ancient societies and which have subsisted for millennia, should not readily be devalued in a contest with wealthy property developers with substantial funds at their disposal. Certainly in the Shell matter, anticipated losses in excess of 1.3 billion were not considered to outweigh the cultural and spiritual constitutional rights in question. This was notwithstanding that the prima facie right there was at the weaker end of the spectrum compared to the right in the present matter. The response of the applicants in respect to the claims by the first respondent regarding the balance of convenience are dealt with in detail in the replying affidavit and annexes at page 2635 to 2644 of volume 7. Again, those references are in the notes. The replying affidavit includes an analysis of the relevant provisions of the development agreement with Amazon Development Company. We highlight the following as far as that is concerned. The first respondent bound itself to an extremely tight construction program for completion of the development before any of the environmental authorization and land use planning permissions had been granted. This is so despite the fact that it is clear from the terms of the development agreement that both parties understood that there was considerable uncertainty attendant upon the timetable, and they purported to structure their agreement accordingly. The development agreement provided for two junctures, two opportunities, at which the developer could assess the viability of the contractual timetable and exit the agreement without incurring penalties. The first respondent elected at their own risk to proceed, and the first respondent has not explained why at those junctures the litigation risk was not factored in. The parties were in any event able to negotiate an extension of 5 months in respect of the agreed practical completion date and lease commencement date. Despite provision for extensions also arising from COVID delays, the first respondent asserts that they simply absorbed those. Why? Following further submissions are made in this regard. Paragraph 79, page 845, volume 3, it is stated that Amazon Development Company recently agreed to reset the practical completion date and consequently the lease commencement date to the dates of 30 November and 1 December. Again, no explanation given as to why the parties did not factor in judicial review proceedings. Insofar as litigation delays are relied upon, there is no reason why the parties should not ensure that the further review hearing and any appeal is conducted on an expedited basis. We've discussed that. Importantly, the definition of anticipated practical completion date in clause 2.1.3 of the development agreement commences with the words unless otherwise agreed by the tenant in writing. In those circumstances and with no affidavit from them, there can be no reliance on assertions by the first respondent as to how Amazon Development Company will use that clause, will react to that clause. The option is certainly open to them to accommodate a review, particularly an expedited review. And I won't take your ladyship there, but I would commend to you clause 2.1.3 of the development agreement. It is submitted that this court should be slow to deny the applicants protection of their constitutional rights on the say-so of Mr. Aufrichter, and in the absence of any full disclosure by both him and Amazon in this regard. Absent that, the word of Mr. Aufrichter is dictating the extent to which the Bill of Rights does or does not apply. The public interest component of the balance of convenience is dealt with at paragraphs 128 to 141, page 2644 to 2650. And Summit has pointed out there that Amazon is committed to commissioning the development of a campus in Cape Town, and if it does not go ahead on the River Club site, it will go ahead at one of a number of other potential suitable sites. The events surrounding the Vogue development cannot support the case that the city seeks to make out in relation to it, and that has been adequately explained in the replying affidavit. Property development companies are well aware of the risk and costs associated with delays in obtaining the necessary approvals, and those are higher when one has, as here, a site that requires rezoning, departures from land use planning policies, site has specific ecological or heritage qualities, and there is a high degree of public opposition to the proposed development. And you will hear my learned friends proceeding on the assumption that it automatically works for the city and its citizens that the construction should go ahead. One has to take into account what the consultants say, that virtually all the comments were against, were negative, were objecting to it. So there's a significant portion of the citizenry who are not in support of the development. In relation to the absence of an adequate alternative remedy, it is clear from the decided cases, including the Shell case, that the appropriate manner of proceeding in circumstances such as the present is to apply for a judicial review of the relevant decisions and at the same time seek urgent interim relief, preventing further construction or the continuation of any other offending activity. The first respondent cites no authority for an urgent review being an alternative remedy to an interim interdict. In any event, we have here today offered them one. The applicant in the letter of the 11th of May in effect offered an urgent review linking holding off on construction with subjecting it to a deadline for commencement, and the first respondent rejected that. Insofar as the issue of urgency is concerned, I think that that's been adequately debated. I see that we are running out of time, my lady. Can I do the following in respect of the strikeout applications? Obviously, in respect of the review grounds that came in the reply in respect of the city, we don't oppose the strikeout, but we would ask if your ladyship makes an order to strike it out notionally for the purposes of these proceedings, because there can be no prejudice if it stays in for purposes of the ultimate review proceedings, because there's going to be an opportunity to file a further answering affidavit.
Only you say that the applicants concede that.
Applicant concedes that. I think it's, if I remember correctly, it's paragraphs 85 to 90 and paragraph 99, if I remember correctly.
Can I get those references again, please?
I'm told not 99, it's 85 to 90, my lady.
85 to 90.